Hi everyone, we're going to go ahead and get started here. Thanks everyone for joining. We're on session 2 of our summer school program, so appreciate all of you joining, and hopefully you're able to catch the last one. If not, you'll be able to look at that on, I think it's on YouTube, so feel free to take a look at that previous program as well. My name is Paul Rothermel. I'm an attorney at Gardner Law. My background is in privacy, HIPAA, GDPR, other privacy laws, cybersecurity. And our firm focuses, if you're not familiar with us, on FDA regulated industry and life sciences. So we do compliance in the healthcare compliance area, from anti-kickback statute to False Claims Act, and other compliance areas. We do privacy and cybersecurity, and then we do FDA regulatory practice, submissions, ad promo review, and so on, and then litigation as well. So today's topic is, do I really need a CPO, a Chief Privacy Officer, a DPO, a Data Protection Officer, or a CISO, a Chief Information Security Officer, or anything really in between? So we'll talk through that today, and we're going to focus on especially the life sciences area. We won't be dealing with some of the other regulations that apply to banking institutions, for example, or financial institutions. So that's the topic today. I hope this is really informative for you, and it gives you some insight into what you can do or what to consider as you develop your privacy and security programs. So a little about me. Before working in Gardner Law, my background was in privacy and med device, a large med device company. I also worked for a state health and human services agency, doing HIPAA implementation work. And I'm also credentialed through the International Association of Privacy Professionals in information program management. So just a quick overview of what we'll talk about today. So we're going to do a little background, kind of looking at the history of CPO roles and kind of ancillary to that, how CISO roles have developed. We'll look also at specifically HIPAA and then GDPR, and then some state laws with what they have to say about this topic, and then some other considerations that I think are really relevant, although explicit law may not be relevant, available there. So we'll talk through that as well. So just at the end, we'll do a Q&A period, but please feel free throughout. There's a chat function with ability to ask questions. Just ask any questions you have throughout the program, and I'll get to them as I can. I really want to be able to answer questions that you have live if possible. Otherwise, feel free to email me afterwards too if you have additional questions. So there's a history to the Chief Privacy Officer or CPO role and similar roles, whether it's DPO, CISO, and really this goes back to 91. In 1991, we had one of the first documented Chief Privacy Officer appointments, and it was in a marketing company at the time, intended really through just a risk management approach to reduce privacy risk at the company. And then since then, we've seen a trend through up to 99 during the dot-com boom, when really this took off and we saw more and more CPOs appointed in major corporations. And that really culminated into 2000 when IBM, obviously a big player at the time in the computing industry, appointed its first CPO. And then since then, through whether it's regulation or simply out of a risk management approach, we're seeing a lot of CPOs appointed in the Fortune 500 in large companies, corporations, and then obviously the EU laws and the Data Protection Directive in particular of 95. We, post that we've seen a lot of Data Protection Officer appointments, Chief Privacy Officer appointments, and so on. You'll see referenced here. There's a Wall Street Journal article titled "The Privacy Officer," and that was a 2001 article that identified a particular CPO as just an example of this trend. And of course, along with that, many federal agencies have had an eye on privacy. So there's many that have someone who's appointed to oversee privacy in that organization. So just as another example of that trend. And similar to that, we're seeing CISOs develop along the same track, Chief Information Security Officers. And again, not out of any particular legal requirement, but simply as a risk mitigation approach. Many companies have appointed a CISO to oversee these programs, report to management on cybersecurity, and oversee that information security bucket as well. So what laws do apply and require or have implications for these appointments, whether it's a CPO, DPO, CISO? HIPAA is an obvious one to consider in life sciences. We have some direct requirements from HIPAA, so we'll look at those. Kind of an interesting one that I want to touch on later, but reference here is the Federal Trade Commission Act. That might raise an eyebrow or two if you're familiar with that rule, but we'll take a look at that and how that might impact considerations around these appointments. And then outside the US, there are many requirements in place. We won't look at all of them. We're going to focus on GDPR today. It really does impact a lot of US companies, so we're going to consider some of its requirements related to DPO appointments. And then state privacy laws. If you're following the news, state privacy is alive and well, even if our federal privacy hopes are faltering at times. We're not seeing a lot of action that seems to go in a full tilt direction towards a national privacy law, but the states have been very active, state legislatures. This is a list. Obviously we're at 20 plus state privacy laws, so that means most companies are impacted by these at some point if you're doing business in any states. And I don't want to say that none of them necessarily require a privacy officer, but many of them require reasonable security and or have a number of requirements that need to be addressed. And so we'll talk a little bit about approaching that and how this conversation around appointment of leadership in these programs is relevant to that. So let's dive into HIPAA briefly, and we'll get into some specifics. So the Health Insurance Portability and Accountability Act, HIPAA, has regulations that specifically outline a lot of rules for what are called covered entities. Covered entities are kind of what they sound like, entities that are required to comply with HIPAA. A covered entity must designate a privacy official who is responsible for developing and implementing the policies and procedures of the covered entity. And they must also designate a contact person or office who can receive complaints or provide further information about the privacy notice that HIPAA requires covered entities to provide. So this is pretty interesting because really it designates someone who is simply responsible for developing and implementing policies and procedures, but this is one of the main requirements that covered entities initially will deal with when they're setting up a privacy program, because this person will take on responsibility to develop and implement the policies and procedures. So that's key. What I will note is privacy officers are officials, as it's called in HIPAA, are only required in this case for covered entities. It only references those. So in this slide, you'll note who appoints them, covered entities. You'll note business associates are not specifically listed when we're talking about the privacy official role. And I think there's a few reasons for that, but chiefly covered entities are not, unlike business associates, have a lot of flexibility and a lot of opportunities to use and handle PHI, protected health information, in different ways. So having that oversight from a privacy officer or privacy official is very apropos. It makes sense. There's a lot of flexibility in decision making, and having oversight is very logical. Whereas a business associate typically is pretty confined in terms of what they can do with information. So these responsibilities are listed here again, and what's interesting too is there aren't any specific qualifications for the privacy officer or official here. It's an appointment that has a responsibility, and obviously it's in the best interest of any company to pick a privacy official who can fulfill those properly, but there aren't any specific qualifications listed. Now, security official. This is a secondary requirement from HIPAA. First, note that it shows both covered entities and business associates must appoint a security official. And then also, the responsibility is very similar to what a privacy official would have. It's identifying security or identified a person who's responsible for development and implementation of policies and procedures, again, for that covered entity or business associate. So this person is an overseer of the program. They aren't necessarily required to implement every element or piece or security control, but they have a overarching responsibility to develop and implement the program. So again, who must appoint one? Both covered entities and business associates. So this is the requirement, unlike the privacy official, that covers both entities, both types of entities under HIPAA. And that has implications for life sciences companies, especially. A handful, many life sciences companies are not covered entities. There are some that fulfill that role, maybe durable medical equipment manufacturers, it's like insulin pumps, other products like that. But there are limited applicability there. When it comes to business associates, however, this is a much broader pool of life sciences companies, and security official responsibility applies to all business associates. So again, just pointing out that these are individuals who are appointed officially and formally, and these appointments have to be documented. So HIPAA requires that any time that these appointments are made, that it's documented that this person is responsible for these things. Kind of a general principle in legal terms is if it's not written down, it didn't happen, right? So we want to make sure that we're putting evidence into our records of these fulfilling these duties. So that's HIPAA. HIPAA is pretty straightforward in terms of who is responsible to do this and when it's required. So if you know we're a business associate or we're a covered entity at this company, it's clear this is what we have to do to comply with these standards. Now we'll talk about a rule that is not so black and white. So GDPR has a data protection officer requirement, and we'll get into that here. So the GDPR has a few different articles that discuss this topic. Article 37 talks about the appropriate time or who needs to designate this role. Article 38 gets into some of the tasks, and then Article 39 talks about kind of what the position entails. What is the entity's responsibility and what is the individual's responsibility with that role. So Article 37 says that a controller or processor, so either one of these, controller being responsible for determining the purposes and means of processing of personal data, and the processor responsible for fulfilling and carrying out that processing on behalf of a controller, they each have the responsibility to designate data protection officer if these apply, right? So one of these criteria apply. You'll see I've bolded and italicized part of C here, where it says the core activities of the controller or the processor consist of processing on a large scale special categories of data. So special categories of data, I mean, that sounds really arcane, but really what that means is there's a list within GDPR of different types of data that specifically are special categories. One of those is health data, or data concerning health, personal data concerning health of individuals. So that's what we're talking about here. And large scale is an interesting discussion. There isn't black and white law around what this means, but generally some of the things to consider are okay, how many data subjects are we talking about? What is the volume? How many data elements? Is it, a few things like name and address, contact information? Is it a lot of information, many data points about an individual? So number of subjects, volume of data, how long is it processed? Is it a few weeks and then it's deleted? Is it held for 25 years? Think about clinical trials, for example. Is it geographically located within a small space, all within Europe, for example, in one country? Or is there a geographical international boundary being crossed? So a US sponsor, for example, of a clinical trial receiving data from Europe, or maybe it's a consumer marketing activity that leads to information being flowing back and forth. So those are all considerations in determining if there's large scale processing. And then part of the interpretation here is various data protection authorities in Europe have looked at this and tried to identify some loose standards, numbers that you might think, okay, if it's over 100 or if it's 500 or some cases 100,000. So different data protection authorities have opined on, okay, this is kind of a large scale processing activity or not based on some numerical approaches. So all that to say, this is a topic to consider carefully if a DPO is necessary, and there are various things to consider. Many life sciences companies doing clinical trials, for example, will take into account, well, we're dealing with a special category of data, it's health. The number of subjects is, okay, it's maybe over 100, so it's not a small number, it's a number. And then what about the volume of data elements? Well, it's a pretty large volume of data elements in a clinical trial. The duration is very long, data's flowing to the US. Well, we start to see that maybe 3 out of 4, or maybe even all 4 of these criteria or factors that we should consider from this based on guidance lend us to need to appoint a DPO. So out of caution, or even feeling obligated to, and we see a lot of DPO appointments in this area. So what about the qualifications of a DPO? So this is from Article 37 as well. So the data protection officer is supposed to be someone who's qualified. They need to understand data protection law. They need to be able to fulfill tasks, which are outlined in Article 39. And they can be either internal or an external consultant or attorney, or lawyer. So it can be different based on the company's needs or size. You can have either a full-time staff fulfilling the role or an external person. I noted in recital 97 here that it says the level of expert knowledge should be determined in particular according to the data processing operations carried out and the protection required based on what that company's processing. So, if it's a very simple, low risk kind of processing, perhaps you don't need a really, highly trained expert, but if it is kind of on that more sensitive data set that you're dealing with and complex systems, you have multiple vendors involved and so on, okay, maybe it's a wise thing to get a higher level of expertise involved in this role. And one thing to note too is, it's not mentioned here, but there is a requirement that there not be a conflict of interest. So if you appoint your DPO and they're also your CEO, for example, there's a very natural conflict of interest because they are determining on behalf of the company ultimately, in a lot of cases, who and how and what is done with personal data. And then they're also overseeing that and auditing it and giving advice on that. So there is a obligation that the DPO appointment doesn't create a conflict of interest. So many times those involved in decision making at the company should not also be taking on this role. It should be an advisory role, similar to sort of an audit role, for example. So some more details about the position and role of the DPO. So ultimately, a key part of this is that the company and the individual DPO have responsibilities. So the company has a responsibility to bring the DPO in when they're doing various kinds of processing of personal data or making decisions about that, they're supposed to make sure that they're informing the DPO so they can give advice, so that they're not kind of left out on the side and not aware. And they're also supposed to give resources to fulfill tasks. They're not supposed to interfere. If the DPO has an opinion on something, they're not supposed to direct them to give another opinion, for example, right, and interfere with their role. So there's some protections in place to make sure that the DPO is properly able to do their job. And then the DPO on their side is responsible to go ahead and support data subjects who contact the company and communicate with them. They're responsible to oversee data protection activity at the company. So if there's data protection impact assessments, which we talked about in our session 1, those kinds of things need to be overseen and reviewed by this person. So some of the tasks that we have listed, and this is kind of interesting that GDPR in particular has outlined tasks. You know, we've seen in HIPAA, for example, a pretty limited set of tasks: develop and implement policies and procedures. Here we have a broader set of responsibilities. So these are including to inform and advise the company, the controller or processor, and its employees to carry out their obligations according to the law. So whether it's GDPR or other union member state data protection provisions, that's part of their responsibility. They're supposed to monitor the company's compliance with GDPR, do some training, assign responsibilities, and so forth. So they're involved in guiding the company's compliance. They're not responsible for compliance, but they're responsible to guide it and help as a consultative, advisory, and directive role. They're also supposed to give advice. So as I mentioned in DPIAs or data protection impact assessments, to be involved in those and give advice as requested. They're not obligated to kind of stick their nose in and do that work, but they're supposed to give advice upon request and kind of monitor the completion of these DPIAs. And then they're also assigned the responsibility of communicating with supervisory authorities. So these data protection authorities in the member states where the company operates, or if there's one particular authority that's overseeing that company, they're cooperating with. So if there's a data breach or if they have a data protection impact assessment that may have a high risk of harm from the processing activity, they may communicate with the supervisory authority on behalf of the company. And similarly, you can see that in bullet E as well. And ultimately, all of these are functions that are filled by the DPO, ultimately to help the company comply better with GDPR and avoid running afoul of those rules. So that's a quick summary of the DPO role. And again, those are some complex decisions in terms of when to appoint, but the bottom line is you do need to appoint one in certain circumstances. There's some risk assessment involved in deciding when to appoint, but that's a key role to consider. All right, let's talk briefly about state laws and regulations. And I think this is probably one of the more obscure parts of law that we haven't seen a lot of discussion around, in even nationally. So within Massachusetts in particular, there's a rule based on some fairly recent legislation that covers the development of an information security program. So any company that is, or persons that process, that own or license personal information about residents of Massachusetts are obligated to establish a sort of information security program. And one of the requirements that is interesting is that this company designate one or more employees to maintain that program. And then along with that, there are some duties, and I've paraphrased some of those here, that employee will carry out. So you'll see some similarities to some of these other rules, developing policies, kind of overseeing and monitoring safeguards to limit the risk, but also some things that aren't in these other rules, documenting responsive actions after an incident. So if there's a breach, doing breach response, post-incident follow-up, preventing terminating employees from accessing personal information. So there's some, you can kind of see that these are security-oriented tasks, but this is a pretty specific set of responsibilities. So again, this is worth paying attention to if you're doing business and processing personal data in Massachusetts. And then a second state has a rule that addresses information security programs, and it's called the New York SHIELD Act. Essentially, it's a update, a revision to the New York breach notification statute to add what it essentially considers a reasonable security standards, which are spelled out somewhat for businesses that do, are operating in New York. So really, it's trying to be fairly broad and requires businesses that process personal information in New York to implement reasonable data security. And then it has a number of elements of a program that it considers to be reasonable. One of these is that the company designates one or more employees to coordinate the security program. So there's again, kind of this reference to designating someone to be responsible for, in this case, coordinating, but in other, leading, developing, implementing, those kinds of terms, this kind of program. And this does provide an exception. So many businesses that operate in a kind of a smaller level, so whether that's through gross revenue, whether that's through a small amount of data that's processed, small number of employees, there are some different qualifications and exemptions here. But I do want to note that this is a pretty broad, specific requirement for companies doing business in New York. There's also a, even if you are a small business, it still requires reasonable security. And we'll get back to that later, but there's a concept of reasonable security that flows through, remember that list of 20 different state privacy laws. That concept of reasonable security is flowing through most of them. So that's worth considering too as we consider this topic. So we're going to get into some other considerations here. One of those that I think is very relevant in particular is the Federal Trade Commission and their activity in terms of enforcement around privacy and cybersecurity. So the Federal Trade Commission Act prohibits unfair and deceptive acts or practices, and the application of that to privacy and cybersecurity is in the past, particularly in the past 20 years or so, especially recently, we're seeing the FTC take action against companies that have data breaches, that misuse personal information allegedly, maybe in ways that consent wasn't collected for, and so on. And then part of that is, hey, you told your customers, your consumers that purchase your product that you would maintain reasonable security or industry standard security for their information. And then in the FTC's view, following a breach, they would say, maybe you didn't do that. And here in this complaint, we'll outline why. In particular, I want to point to a fairly recent enforcement action against company Drizzly LLC. And if you're not familiar, it's similar to kind of an Uber Eats, but it's now out of business, but for alcohol deliveries, so alcoholic beverages. And so not necessarily a life sciences company, right? But they have a really interesting turn of events in this complaint and the ensuing order. So the FTC had alleged this company's statements about safeguards were unfair and or deceptive, We'll get an example of some of the statements that they thought were unfair and deceptive in the next slide. But one of the things interesting in the order that came out of this is there was an obligation that the FTC ordered to establish and implement and maintain a comprehensive information security program, including to designate a qualified employee or employees to coordinate and be responsible for the program. So that's interesting. Not just because it's in the order, this interestingly didn't appear in the complaint as an element of a failure to have a reasonable security program, but in the consequence of pointing to, hey, we need to remediate this inadequate cybersecurity program, allegedly, we think you should have this role filled. So probably Drizzly had made some fairly aggressive statements, right, to indicate we have a great security program. Well, let's take a look at one of the statements that the FTC took issue with. Here's an excerpt from Drizzly's privacy policy. So this is something that consumers would have been able to review before they submit information to Drizzly. Here's their statement about their security. And I'll just quote a brief period of this. All information we collect is securely stored within our database, and we use standard industry-wide and commercially reasonable security practices. And I'll skip a little bit. We cannot guarantee the security of our database, nor can we guarantee that information you supply won't be intercepted. Okay, I mean, that sounds fairly even, right? Commercially reasonable. We don't think we can't guarantee anything. We'll take reasonable steps, industry standard kind of approach, right? But the FTC did take a look at this and say, well, you didn't have a security program that sufficed. So we'll enforce this order that includes appointing a security officer. So I think that's really interesting and points to a trend towards what is reasonable security, and whether that for some companies, especially larger companies or companies that process sensitive data, they should really be considering if reasonable security, which it sounds pretty broad and loosely defined, whether that might include appointing someone to oversee their cybersecurity efforts. So let's kind of evaluate this generally. So if we have, let's say we're a company that we don't operate in Europe, we don't have to appoint a DPO, we don't operate under HIPAA, so we don't have to either appoint a privacy official or security official. We're just sort of in the margins where none of these explicit requirements apply, and we don't operate in Massachusetts or New York. Should we really have to deal with these requirements? Should we appoint someone to oversee these programs or give oversight? I think in most cases, it's a risk-based assessment, right? So there's not a one-size-fits-all answer, but some things to think about. More and more privacy and cybersecurity laws have mandates to do certain things, and I'm thinking especially of privacy as it becomes more and more robust in terms of we need to address website requirements. We need to track and understand the flow of data within our company. We need to do risk assessments of personal information to identify, is this processing activity appropriate? Does it follow the law? Does it address any potential harms to data subjects? We have to have contracts in place with service providers. We have to do risk assessments of service providers. There's a lot of things to do to completely comply or substantially comply with privacy laws in various states. There's the idea of reasonable security. Reasonable security more and more is not so undefined because there are generally accepted principles that a cybersecurity program should implement. Whether you look at NIST or ISO, various frameworks of cybersecurity, there are some standard things that you'll see, and often policies and procedures are almost always present in these programs. Having some sort of oversight and audit function, really there's a lot to unfold there, but there's some commonality and generally accepted approaches. So reasonable security is developing into something that's that's pretty mature, we can identify what reasonable security is more easily. And in many cases, that's going to include having a CPO or a CISO in the company, whether that's a full-time role or not. And then, so any program, think about this from this perspective, any program that a company is going to develop, whether it's a privacy program, a compliance program, a marketing program, anything that you develop is likely going to need a leader, someone who's responsible and accountable for that delivery of that objective or deliverable or ongoing management. So I really think this is in some ways simply an operational reality that someone needs to be responsible, and that's a part of it too. And then lastly, we had that discussion in the beginning of the program about CPO and CISO roles, and those are both in their origin not regulatory mandates, but really something that businesses identified as a need because they saw we have a risk, we have potential data breaches or misuse of information that could lead to fines or unhappy customers or harm to customers. So really it's a matter of what kind of risks can we address through putting and appointing responsibility to someone that can oversee these things. So I think those are all things to consider, even if in black letter law there may not be a requirement. So a few takeaways here before we wrap up. Requirements vary. They vary across all jurisdictions. So as we discussed, you could look to the jurisdictions that you're in and identify requirements. Obviously HIPAA, we have the privacy official required for covered entities, security official required for both business associates and covered entities. GDPR, the data protection officer, again, we've got to consider, are the conditions met? You know, do we do business in Europe? Do we have this high volume of large scale processing of special category health data, for example? So again, evaluate that if that might apply. If you're doing business in these specific states, you should definitely consider if those apply and whether that, you know, specifically requires that you implement these programs if you haven't already, and appoint someone to oversee them. And then I think more on the risk management side, or kind of reading the tea leaves, should there be a cybersecurity leader or privacy leader or both, based on the kind of business you're doing? Is that something that would be expected, a reasonable expectation, given the industry you're in, the kinds of data and volume of data that you're processing? And really, would it be best for stakeholders, for patients, for your business? So I think that's something to keep in mind and consider as we go forward. So that's it for this presentation. I'm happy to take some questions if you have any. Looks like I have a question here. Let's read this one. So this question is, my company is a pharmaceutical company and it's operating in a clinical trial in Europe, but otherwise the company is based solely in the US. Do I need a DPO? So yeah, that's a great question. It's difficult to give a definitive answer, right? Because there's variables here. But generally, if you're operating a pharmaceutical clinical trial, there's a large volume of data subjects involved. So you probably do meet that large scale processing threshold, and you probably do need a DPO. We have helped some clients with this, and I've acted as DPO in some cases for some clients as well. I think we have one more question here. So other than HIPAA, do any US laws require a privacy officer or CPO? So this is specific to privacy. We've talked about some laws that require security leadership, but here's privacy. So in banking and finance and insurance, there are some sectoral laws that address this, but we haven't focused on that here. So if you're in those industries, look to those laws that apply to your specific industry. In the life sciences industry, though, it's really HIPAA and then potentially kind of a general standard approach of what kind of promises are you making in terms of your privacy policy. Do you promise that you'll do industry standard privacy practices, which typically would involve a CPO for larger or companies that handle large sensitive personal data sets. So that's something I would consider, but there really aren't any specific laws outside of HIPAA in life sciences. Okay, I think that's it for questions. Again, thanks everyone for staying with us, and really glad that we could share this information. We'll have our third session in a few weeks on really what kind of website things to consider on your website. So we'll do that next. Thanks so much.